Hello friends. Today we are going to discuss about what are the changes which has been adopted under Bharatiya Nagarika Suraksha Sanhita 2023 and what a psychiatrist should know. That is from the forensic psychiatry perspective. And what are the changes from CrPC to Bharatiya Nagarika Suraksha Sanhita. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about from the forensic psychiatry perspective, the Bharatiya Nagarika Suraksha Sanhita 2023, that is Criminal Procedural Code, which was there earlier. So, in this regard, we will see what are the changes and what are the implications a psychiatrist should know. Further, applicable to forensic psychiatry is Bharatiya Nagarika Suraksha Sanhita's Chapter 27, from section 367 to 378, that is provisions as to the accused persons of unsound mind, will be discussed in this video. Let's look into Bharatiya Nagarika Suraksha Sanhita 2023. Here, there is an important clause which says mandatory presence of forensic person, which was not there under CrPC, that is Criminal Procedural Code. What is that code? Under section 176, subsection 3, for the procedure for investigation, the Bharatiya Nagarika Suraksha Sanhita 2023 says that significantly increases the involvement of forensic science by mandating that a forensics expert should be present during the investigation of a crime scene for all offenses punishable 7 years or more, that is heinous crime. That's what I can put across. This provision is found under 176 subsection 3. It aims to ensure scientific rigor, transparency, and accuracy in the criminal investigation by making the collection of forensic evidences compulsory from the outset by the forensic expert. Forensic expert may be forensic medicine, forensic psychiatrist, or even fingerprint experts. Various other forensic science people need to be there. This is an amazing welcome step, because forensic science every day it is improving. So we will be able to help the police in solving the crime and punishing the accused or the person who has committed the crime. Now let's move into psychiatric aspect. Bharatiya Nagarika Suraksha Sanhita 2023, under chapter 27, provisions as to the accused person of unsound mind is there. The complete chapter has been dedicated, which is equivalent to Criminal Procedure Code 1973, Chapter 2025. That is also provision as to the accused person of unsound mind. From 328 of CrPC to 339, 12 sections were dedicated for a person of unsound mind. He has been accused of committing a crime. The equivalent under Bharatiya Suraksha Sanhita 2023, Chapter 27 has been dedicated. Here the same title is there, provision as to the accused person of unsound mind. Again, section 367 to 378, 12 sections have been dedicated, my dear friends. So there is no change in the title, but however the chapter has been changed from 25 to 27. So this section has got the promotion from 25 to 27. If you look at, there is no change. There is only a cosmetic change from CrPC 1973 to BNSS 2023. The cosmetic change is unsoundness of mind has been added under BNSS 2023, but however in CrPC it was considered as lunatic. This is the only word which has been changed. Otherwise it is completely A to Z copy paste. There is no changes with regard to the provisions as to the accused person who is unsoundness of mind. There is no change at all. Only the cosmetic change. Instead of lunatic, unsound mind has been considered. Wish it would have been person with mental illness. That had been recommended, but that also has been completely discarded. Now let's look into each one of them. Section 367 of BNSS, Bharatiya Nagarika Suraksha Sanhita, procedure in case of an accused person being of unsound mind. Imagine a person who has committed a crime and he is unsoundness of mind. What should be done? The magistrate, when he comes to know that there is an accused person has been of unsound mind, immediately he will order the civil surgeon to examine him. And if the civil surgeon feels, yes, this person has mental illness, he will refer him to a government psychiatrist. The government psychiatrist will examine him and issue the certificate. And if by chance the accused does not feel that he is not mentally ill, or he feels he is mentally ill, and the government psychiatrist has not done his job properly, it will be appealed to the board. The medical board will be consisted of head of the psychiatry of the government hospital and a faculty from the government medical college. These two people will form the medical board at least, and they will give the opinion, my dear friend. Once the opinion is given, then it will be dealt as per the section 369. What are those? If there is a prima facie case is there, what should be done? If the prima facie case, if it is not there, what should be done? And if there is intellectual disability is there, what to be done? If the prima facie case is made, that means he is mentally ill is there, and also he has committed the crime. The police is able to give the prima facie evidence. If it is there, under section 369, it will be dealt. If there are no prima facie, there is no evidence against the accused, and he is mentally ill, under section 369, the case will be closed. If he is intellectually disabled, and if there is no prima facie case, again the case will be closed. If there is a case is there, it will be dealt under section 369. You are clear? Now I'll be discussing shortly with regard to section 369. Let's move to section 368. Here, procedure in case of a person of unsound mind tried before the court. Already the case has gone and then the case is ongoing now. That means unsound mind can occur when the case is also going. Invariably in India, the cases runs for decades. So during this period, a person may become mentally ill. What should be done? The magistrate, whenever he finds the accused is mentally ill, that means unsoundness of mind is there, he will refer to a government psychiatrist again. The government psychiatrist will issue the certificate. But the accused does not agree with the government psychiatrist report, again it will be referred to medical board, which will be considered of head of a psychiatrist of government hospital and a faculty of government medical college, and they will issue the certificate. And then again the same will continue. If the prima facie case is made, prima facie cases continues to be not there, or intellectual disability, and it will be dealt as per section 369. Let's look into this section 369. It has been repeated twice. Release of a person of unsound mind pending investigation or trial. Imagine a person is mentally ill and he has been arrested and he is kept in the prison, and the case has to undergo. In such a scenario, the court, what should it do? What should the magistrate do? That is dealt under section 369 beautifully. Accused is unfit to stand trial because his unsoundness of mind is found. In such a scenario, bail is granted, my dear friend. Another important, a friend or a relative should undertake that they will provide a treatment, either OPD basis or inpatient basis, and they will make sure neither he will harm himself or others. That has to be given in writing to the court. If accused is unfit and bail is rejected because of various reasons, or else the friend or the relative may not give an undertaking at all. They are scared about him because he has killed his own family member, and the family is fed up because of him. They may not give the bail at all. The family will say, please take care of him. Let him be in the prison. What are the possibilities in such a scenario? The transfer of the accused to a residential facility, my dear friend. Residential facility can be anything. The definition of residential facility is not been there at this section. It can be hospital, it can be prison, it can be a hospital within the prison facility. It can be high security prison, or you can consider it as a psychiatric ward in the prison, my dear friend. It can be anything. Or else the state government can form a residential facility for these people separately. It is left to each state government, my dear friends. So that is what about 369. That means either give a bail, hand over to the family members, or else he will be kept in a residential facility. Now let's move to section 370. You have handed over the person to family member. Now resumption of inquiry or trial. That means once he goes with the family members and he is cured now. That means the case has to resume, because it's a criminal case. It cannot be just wavered off. In such a scenario, whenever he is fit, whenever an inquiry or a trial is postponed under section 367, 368, under 369, the magistrate may at any time, after the person concerned has ceased to be unsound of mind, that means he became all right, he will refer the person to government psychiatrist and he will certify. And the case will resume, my dear friend. Because the case is only the bail is granted, is not been said is acquitted. The case has to be resumed and the court has to give the verdict. Till then, the case will be on. Now let's move into 371, procedure on accused appearing before magistrate. So here, consider him is capable of making his defense. That means he is fit to stand trial. The case will proceed. Suppose if he continues to be incapable of defending himself, that means he is unfit to stand trial. Again, the case will be dealt under 368, 369. That means you will be handed over to the family members, or else you will be kept in a residential facility. That the family members or the relatives have to give in writing that they will take care of him so that he will not injure himself or others. Now let's move into section 372. When accused appears to have been of unsound mind. Here the magistrate considers him, here the magistrate himself will say that yes, he is able to defend himself. The magistrate will go ahead with the continuation of the proceedings, that is inquiry, and the trial will proceed. Section 373, judgment of an acquittal on the ground of unsoundness of mind. This is where the important point. That is, if the person is found unsoundness of mind and he is acquitted on the ground of unsoundness of mind, that means he is mentally ill and he is not responsible for his act. That has to be dealt as per 373 of Bharatiya Nagarik Suraksha Sanhita. What does it say? The magistrate, when acquitting a person of unsoundness of mind and he has committed a crime, and during the commission of crime, he did not know the nature of the act, consequences of the act, and or contrary to the law, and the magistrate wants to acquit him. And when he is acquitting him, the magistrate needs to specifically say that whether he has committed the act or not. If there is no prima facie case, there is no evidence, the court will say he has not committed the crime and they will just ask him to walk away. No, if he has committed the crime and under BNSS 373, they will say he has committed the crime, but he gets the insanity defense. That means commission of the crime has to be reported, or in the judgment it has to be told whether the accused committed or not committed before acquitting him. If he is not committed the crime, that means he will walk away. If he has committed the crime, and then the magistrate has to say. That's what the BNSS says, my dear friend. Now let's move to section 374. Person acquitted on grounds of unsoundness of mind to be detained in safe custody. Now the magistrate has decided to acquit him, and he has already clearly mentioned thus he has committed the crime, but because of unsoundness of mind, he is not responsible. In such a scenario, when acquitting on the grounds of unsoundness of mind, the magistrate has to take certain important points to be considered. What are those? Safe custody as per the court. That means he is a person with mental illness, and if he goes outside, he may again commit a crime. So safe custody has to be given. The court has to consider this. He cannot just walk around in the community. So that safe custody has to be clearly declared, or else he has to be delivered to any relative or friends who is able to give in writing that they will take care of him either on inpatient or outpatient, and they will provide medicine, and they will make sure that he does not harm himself or others. That means just because he is mentally ill and is not responsible for the act, that doesn't mean he will be sent outside. The court will make sure he is treated, he is cured, or he will be put in a safe custody so that he does not harm anybody, or else he will be given to the family members who will provide treatment. That's the essence of 374. Just because somebody has committed a crime because of his mental illness, he will not be allowed to walk away easily, my dear friends. That means insanity defense is not misused in India. The procedure is very, very strict. And each hearing will take 6 months to 1 year before a person with mental illness is released. And even the relatives have to get him outside. Affidavit has to be filed telling that they will take care of him. Finally, Section 375. Power of the state government to empower an officer in charge to discharge. In the whole section, whatever we discussed now here, the state government will empower a officer. That state government, who is that person? He can be anybody. It can be Inspector General of Prison, or his nominee can be there, who will be empowered under this BNSS, that he will be monitoring the patient, whether he is doing well, whether he is not doing well, whether he is taking treatment. All those power has been given for one officer. What does it say? The state government may empower the officer in charge of the jail in which a person is confined under the provision of Section 369 or 374 to discharge all or any of the function of the Inspector General of Prison under Section 367, 376 or 377. So he will monitor and update the court. So an officer will be recruited or will be given power to do that. Section 376, procedure where a prisoner of unsound mind is reported capable of making his defense. The officer who is there under 375, if he says that the person is unsound of mind is there, he has been cured and he is doing well. In such a scenario, this officer who has been nominated will give a report to the court, yes, he has become all right. In such a scenario, the Inspector General of Police or the prison will issue a certificate. If he is in jail telling that he is all right, the case can resume. Or else MHRB, the Mental Health Review Board, if the patient is outside in the community with the family members or relative, MHRB, that is Mental Health Review Board under Mental Health Act will certify telling that he is all right, or he is in the hospital, he is all right, and the case has to resume. Section 377, procedures where a person of unsoundness mind detained is declared fit to be released. Suppose he has to be released, Inspector General of Prison or a visitor shall certify that in their judgment he may be released without any danger to himself or others because he has been cured. 377 will be applied. The state government, once they certify, the state government may order for his release, or else if they feel that no, he is not safe, he has to be detained in custody, the state government will decide, or to be transferred to a mental hospital, the state government will decide. But the Inspector General of Prison or the visitor has to certify. Above that, the state government will decide what to be done. So to detain in a public mental health establishment, a commission needs to be formed. A commission consists of one judicial officer and two medical officers. They will say, yes, he has to be released or he has to be detained in the mental hospital, will be given, and the state government will act upon that. Section 378, delivery of a person of unsound mind to a care of a relative or friend. In such a scenario, the state government will scrutiny the application received from a relative or a friend under section 369 or 374, telling that the accused is a person of mental illness and they are going to take care of him. And they will provide treatment either OP or IP basis, and they will make sure he will not injure himself or others. That person will be delivered to a relative or a friend if they agree for. So that clearly says they have to properly take care and need to produce him whenever the inspector of prison or such officer telling that they want to see him, and he needs to be produced in front of the court whenever the court calls. Then only they will be handed over to the relatives or friends. And the inspection of such officer will submit the report to the court based upon his assessment, my dear friends. This is what about 378 under BNSS. So, in the Bharatiya Nagarik Suraksha Sanhita 2023, mandatory involvement of forensic expert is a welcome step, especially with regard to any heinous crime. There are no major changes from BNSS 223 to CrPC 1973 regarding dealing of a person who has been accused of committing a crime and who has unsoundness of mind. Both are same. There is no change apart from a small word called as from lunatic to unsoundness of mind. But however, my critique is clear. These words such as unsoundness of mind should have been removed completely. Person with mental illness has to be introduced. Invariably, UNCRPD, what India has signed, we need to have a dignity to a person with disability. We should not use such word called as unsoundness of mind, lunacy, lunatics should be removed. Hope in the next corrections in the BNSS and also BNS, unsound mind word will be removed and a person with mental illness will be brought in. Thank you very much for giving your valuable time. Stay safe.